First of all, thank you very much for the invitation to this event, and congratulations to the whole organizing team. I mentioned it yesterday actually already. It's one of the best organized events I've been to, including compliments to the whole organizing team. My task today is to chair the roundtable. When I was looking at the program, I realized that there is actually no specific speakers or people invited for the roundtable. So actually, it's all of us. So it's my pleasure to chair that this roundtable. And for the, let's say, sake of facilitating the discussion, I would like to, in the first couple of minutes, just raise a couple of issues, which I hope will serve as a basis for debates, which can turn apparently in various directions, because as we know, with roundtables, one can stick to one specific question, and that will be it for the 1.5 hours. Or we can simply, and you are most welcome, of course, to add any kind of issues which you deem relevant, and skip actually what I will be, let's say, talking about. Just maybe to start, the let's say title or the topic for today is upcoming challenges in balancing human rights and IHL obligations in counterterrorism operations. And if we separate that title, it already gets not easy, because actually each part of this is already let's say raising issues. First of all, we I guess all agree that while both human rights law and IHL aim to protect in some way individuals in different contexts, the counterterrorism and its, let's say, nature blurs the lines between war and peace. It's not really sort of fitting neatly into the usual frameworks which we have, especially when we talk about non-state actors, when we look at hybrid operations, when we look at how actually counterterrorism has redefined the concept of the battlefield by extending the battlefield beyond traditional conflict zones, and including the remote, let's say, war. I guess we also agree that there is an ongoing need for clarity, especially with the increased use of technology and the rise of non-state actors in global conflicts, and that this simply constitutes a practical challenge in balancing, on the one hand, state security concerns with the protection of fundamental human rights. So when I was thinking about this topic, I would suggest certain basic premises that may frame the discussion. The first one is a very simple and obvious one, that even terrorism negates fundamental principles of both IHL and international human rights law. Apparently, are obviously the answer to it should not just do the same. That's a very first basic premise for me. The second one is that even if we consider application of IHL and international human rights law in counterterrorism operations, already in this, let's say, separate issues continue to raise a lot of questions. We can see that when we look into the relevant, for example, reports. When I was looking into the reports of the Special Rapporteur on the promotion and protection of human rights while countering terrorism, or when you look into the September 24 ICRC report on challenges to IHL, so we see that counterterrorism continues to be, or countering terrorism continues to be a challenge on its own in the specific context of IHL in international human rights law, including the very basic questions when we like applicability of IHL to counterterrorism operations, where some states still continue to deny that IHL applies or may apply, including assessing any act of violence by non-state armed groups in armed conflicts as acts of terrorism, and therefore raising the question whether they are lawful or unlawful, depending on the whether we consider IHL to be applicable or not. Nevertheless, and this is maybe just a side issue, one interesting fact is that when I was looking at the ICRC report from September this year, compared to the other reports, the last one was 2019, counterterrorism for the first time has no specific chapter. It's not mentioned there. So it's quite interesting because previously it had a separate chapter with a lot of sub-issues, but this time it was mentioned only very, very marginally, and apparently other pressing issues in the context of IHL have taken place of the issue of IHL application and counterterrorism operations. But the point is here that we already have a lot of issues which arise separately when we look into application of IHL for human rights law in counterterrorism operations. And the third premise is that the existence of a tension between international human rights law and international humanitarian law in counterterrorism operations arises out of the different main purposes, scopes, and mechanisms of application of these two fields. And I think that actually exploring the tensions of these two areas is what can be a very valuable exercise for these 1.5 hours we have. And the specific questions and challenges which result out of this tension are primarily a tension between what I consider a broader permissiveness of IHL and restrictiveness of international human rights law. And I would like to give you one example, even though that example is not specifically from a counterterrorism operation, but it can be set into this context. Just a few days ago, I was approached by the legal service of the Czech army with a question that they have a situation when the Czech army is deployed in a situation of an international armed conflict. And that there are civilians coming, meaning IDPs, migrants, etc., and that there is a so-called human unit, so human intelligence unit of the Czech army, which would like to have access to the phones of these civilians. And the question was how to deal with the fact that some of the civilians do not want to provide the access to their phones. And there was diverging views between the lawyers in the legal service. Some of them were saying, well, it's a situation of an armed conflict, IHL applies, and that's why this security threat it's a different situation than if we would consider it under the pure peace situation where human rights law applies, and that IHL in that sense permits more. If we look then into more detail, we see that IHL actually does not contain any specific rules on data protection, privacy, etc. So the only thing we could apply are the general principles of proportionality, military necessity, etc., etc. Whereas, if we indeed apply international human rights law, we do have very specific guarantees, and if we would argue that it is a situation when the Czech armed forces would exercise in some way jurisdiction over these persons, then we have the question of extraterritorial application of human rights, and therefore also the high standards of the European Convention of Human Rights when it comes to the right to privacy, private life, data protection, and all the other obligations resulting from the Czech Republic, let's say, human rights commitments. So this is, for me, an example of this kind of tension, which is quite interesting, that we have the two areas of law. In some situations, it might be of more benefit for a state to apply the IHL rules, as in such a situation where one of the lawyers were saying IHL, and that's it. And that's why actually our hands are more free. We can actually detain the person, and just the fact that the person is not willing to give us access to the phone is sufficient to consider this as a security threat, and we can even detain the person. And then there was the other opinion of another member of the legal service saying, no, we actually have to consider also the human rights, because they do apply also during the armed conflict. But the question is, of course, to what extent, and how does it intertwine, and how does it play with the IHL rules then in such a situation? So for me, this is some sort of situation which I think that shows how many issues arise in situations which, at the one hand, as I said, this was not a counterterrorism operation, but could be. And we know that the question of obtaining intelligence and information is something which is very important in counterterrorism operations. So if we translate it to the counterterrorism context, this for me shows the issues, let's say, arising out of this tension. And basically, then when we the two biggest issues, and that's my, let's say, suggestion for a starting set of issues, because I don't want to just provide this example, but it was just an example. But for the roundtable, we have the two areas where the tension between international human rights law and IHL is particularly interesting, and that is targeting and detention. So this would be, let's say, my suggestion for the discussion and for the questions we could discuss, starting from the very basic premise or from the very basic question of the applicability and the relationship between the two areas of international law, going through basically the question of what happens if one set of the rules actually is very precise, but in the other context, like in the situation which I was mentioning, we, for example, do not have any specific rules. So actually, how to cope, how to deal in these cases? Shall we just go and use the general principles, as I mentioned, for example, in the context of IHL, or and interpret them in the light of the human rights obligations, or what would be the approaches actually, how to cope with these kind of situations when actually we have a certain lacuna or gap in, let's say, legal regulation, which occur especially in the context of international armed conflicts because of the involvement of non-state actors. So that's from me for the beginning, as some food for thought, hopefully. And I would be actually keen to hear from you, whether you take up the example or the situation I was mentioning, or any other issue I was mentioning, or you add anything more specific to start that.
Can you start?
Yeah.
So on the, I like the example, super interesting, huh? I do think there's an answer on the question of extraterritoriality, even under existing case law of the European Court. So you all know that it's a mess, like this case law, right? But I mean, there is a clear line of cases where Hassan versus the UK is the main example. But even in Georgia, Russia, and we're now going to see what's going to happen in the big Ukraine-Russia case, where the court says people who are detained are covered by the convention. And detention doesn't necessarily have to be a long-term one. So if you arrest somebody and deprive them of their liberty to take their phone, I don't see how it could reasonably be argued that the convention doesn't apply. In the Jalud case, the court also applied the convention to checkpoints, to a killing at a checkpoint. So, like, I don't see how, you know, if the Czech authorities, like the military people, are able to physically take somebody's phone from them, I don't think how it could be argued that the convention doesn't apply. You see what I mean? On the basis of those existing cases. Then there's another recent case.
Sorry, Marco, if they do not detain the person, but just take the phone?
But they stopped them. How can they take the phone from the person? It's the checkpoint. How can they take the phone from the person if the person doesn't willingly give it?
No, they hack it.
But that's a different scenario. That's not his scenario.
Yeah, that's the question, and how they deal with the phone.
No, sorry. There is a different scenario, right? On the hacking bit, what you have is case law from the UK. So the UK had a long-standing position, which was then approved by the Investigative Powers Tribunal, the specialized surveillance court in the UK, that the convention doesn't apply to purely cyber surveillance of people abroad, right? Then, however, late last year, I think, the European Court, the chamber of the court, decided a case called Wieder and Guarnieri versus the UK. And it flew a bit under the radar, that case. So in that case, the court said that if you collect data of a person abroad, but then you bring it to your own territory. So if the Czech soldiers in, I don't know where, send data back to the Czech Republic and then do stuff to it, so they process it, analyze it, keep it, yeah? The interference with privacy takes place on Czech soil. And it's really not an extraterritorial case, the convention applies. So the court already said that. The UK didn't appeal. Yeah, they could have appealed to the Grand Chamber. They didn't because they probably thought it was going to be worse if they didn't. So the next sort of frontier on this extraterritoriality business will be the big Ukraine-Russia case. So that's my point on extraterritoriality. I think it will be very difficult to avoid the bottom line conclusion that the convention applies. Then the bigger question is the one we put, which is how does it apply? And you chose a really good example where it's human rights law that is actually much more specific than IHL is. There are many such examples. I examined the PhD, her in Stockholm. Her name is Sally Longsworth, who wrote a PhD on freedom of expression in occupied territory. Yeah. So, consider all the scenarios of what we do with the media in an occupied territory, with internet access in occupied territory, all those things, right? Or surveillance of people in occupied territory, which is like what Israel does routinely to Palestinians and that type of stuff. There's, rules of IHL saying really nothing on this, or they are, rudimentary, whereas human rights law has all this stuff, and occupation in particular is the paradigmatic case of extraterritorial jurisdiction.
Just a quick follow-up question. If we go outside of the European Convention of Human Rights, would it change?
All of the other human rights bodies say broader things. So the European Court is the most conservative of all human rights bodies. So if any of these issues get litigated before any other human rights body, they're all taking more expansive positions. So the European Court is actually like what governments would like. The reason why it's conservative is because the stakes are the highest. You see what I mean? So now in the big Ukraine-Russia case, that case deals with the downing of MH17. It deals with artillery shelling in the Donbass in 2014. It deals with some of the stuff in the 2022 war. Yeah. And the big issue in the case on extraterritoriality is whether the convention will apply to the conduct of hostilities. Yeah. Because in Georgia, Russia, basically the court said, no, we don't want to apply the convention in the context of chaos. Now they're in a completely politically different position. What are they going to say? That Mariupol, if you destroy the whole city of Mariupol, the convention doesn't apply. Yeah. So they're definitely not going to say that. The question is what exactly they're going to say. We have had an unprecedented number of states intervene as third-party interveners, all of them in favor of Ukraine, so like 30-something states. Yeah. All of them have coordinated. So you have layers of joint briefs, and then you have some separate briefs. Of these states, most basically nudge the court to go somewhere expansive. The question is where exactly. Baltic states, Poland, and so on, they basically say anything in war covered by the convention, right? 2 states, and that's France and the UK, basically are in favor of Russia. They say kinetic stuff, forget about it, it's not covered by the convention. So we'll see what the court will say within months, yeah, on that case.
Stuff is not covered?
What they don't want to say is that bombing stuff, artillery shelling, that's covered by the convention, because that's what they do. Yeah. So we'll see what the court will say on that. There's nothing in the case, though, on the merits where you really have this big clash you were talking about IHL and human rights, because all of the allegations are deliberate attacks against civilians. The court invited states to comment on proportionality. They didn't. Yeah. So, IHL proportionality. In particular, whether human rights law, right to life, can accommodate collateral damage. They didn't say anything. Sangeeta Shah from Nottingham and I wrote amicus, so we were third-party interveners. So you can find our amicus briefs if you're interested.
I'll start from the bottom line, which is for me rather intuitively simple and a bit opposite to Marco, and then go back from there. Bottom line is IHL allows you as a matter of military necessity to confiscate stuff. Stuff includes phones, so you can confiscate the phone. Done.
If you're in IHL.
IHL, wait.
If you are within.
Wait.
And if data is a civilian object.
Wait. If
Could.
once, if there's military necessity, I can confiscate the phone. If a person resists to my confiscation, I can detain that person.
Are you talking occupation or are you talking hostility?
Hostilities, of course, in hostility.
Where does it say that you can confiscate private property or that
If I can destroy something, I can confiscate it.
Oh.
No.
Why not?
No.
Why not?
No.
If I can destroy it, I can
No.
confiscate it.
No, because your purpose is different.
My purpose
And where does it say that you can destroy something? I mean, it's not that you
for
can't destroy
military
things.
necessity?
Obviously you can. That's
Come on.
what war is about.
Yeah.
But you're not authorized to destroy things. That's the whole point. You're taking property of a civilian in hostilities. Like it's not a situation in hostilities.
No, but the information
You don't
is
take phones and
assuming that the information, wait, the information, what I need is from inside the phone. It's not a legitimate.
you're confiscating the phone. You're not confiscating
I
your
understood that this is a situation outside of combat area. So a situation of an international armed conflict, but outside of combat area.
Okay, let's
Tell
talk
us
about
where.
that.
Come on, tell us where. Don't boy.
I don't know, Marco.
Where are the Czech troops now? Come on.
Marco, I don't know. They didn't tell me.
But they're not all over the world. They're like in one country. Where are they?
I cannot get classified information.
Situation, armed conflict outside combat area. I mean, we need to establish what the legal framework is. Now, there's hostilities, there's occupation, and we sort of know what that is. We sort of know what that is, and now you're suggesting the third thing, but which could exist. I'm not saying there isn't, but which is why we can continue arguing endlessly.
What I meant is,
You're not going to tell us.
I don't know. No, because it's a classified information.
No,
so that's why I really don't know. That's why I can't give you more precise information because I don't have it simply.
So there's a different issue, the issue of jurisdiction. Okay, once we enter the court was very creative in what it interprets as the rights that exist while trying to mesh IHL with human rights.
What do you mean?
I mean, the fact that the right to life exists, but what is arbitrary killing, it goes back to...
They've never dealt with this. Never. There is no single case before the European Court
that they used IHL as a...
where they discuss a killing in the context of armed conflict and in light of conduct of hostilities rules.
But when
It doesn't.
goes more generally, when they apply what actually the rights mean in the context of hostilities,
They've never had the case. They've avoided merits of such cases. So they've dealt with issues of detention. So with people who are detained and tortured and mistreated, that's what they've dealt with. So in Georgia, Russia #2, in Bankovic, in all of those cases which dealt with destroying stuff, they've avoided. So you have the Human Rights Committee, you don't have the...
But we can learn from Hassan, right?
Yeah.
Like the potential approach, where there are explicit rules of IHL that deal with it. And I think that the question is, right, so if we have like two possibilities, there's a total gap in IHL, then you can assume that human rights will fill this gap. We can have like full articulated rules, we can assume that it will be like Hassan, but what if just like IHL just say, you have the right to enter the property or whatever, but it doesn't specify what it includes, and I guess that they can go both ways.
And can you just easily assume that you just fill in the gap, which might be on purpose in IHL, with human rights law?
So I think that it's tricky when IHL permits, like explicitly permits something. It's not a case where it's like doesn't say anything about detention in NIAC, and then maybe you can have an approach that say, okay, we'll fill it with IHL. It allows you to do something, but it's really not specified, very vague. And here I think that it's a plausible argument to argue to both directions. Like if they allow it, we'll have like a parallel IHL approach, or I don't know.
I think that we can use human rights in every time, and the ICJ says that
in a advisory opinion that you know about Israel, I think I wonder. So, if, for example, the European Court we avoid a case about like that about human rights violation during armed conflict, I think that we can vote you can choose the ICCPR, the UN committee that's the organ that control the application of the ICCPR, the human rights committee of the UN system. I think that maybe we can. I'm not sure that they will avoid a case because it's a question of human rights violation in the context of conflict. I do say if you understand.
If you can just wrap it up.
Okay. If, for example, the European Court of Human Rights avoid a case because it's a question of human rights violation in the context of in wartime, for example. I think that we can use the ICCPR, the committee, the UN, the Human Rights Committee.
You mean file a case in the committee?
What?
You mean file a case in the committee?
Yes, yes.
So that depends on whether the state concerned accepts the jurisdiction of the committee under the first protocol, which many states have not.
Okay.
So there will be gaps there. If you want to litigate cases against states with these issues, sometimes you can go to the European Court. Sometimes you cannot go to the committee because the state concerned did not accept the committee's jurisdiction.
Okay.
But they did, unlike the court, they did explain their position of principle on the right to life in the general comment, and which Yuval was the main author of. And I mean, they say there, if you remember on the right to life, they say in general, killings compliant with IHL are not arbitrary, they do not violate the right to life, which leaves open the possibility that sometimes, in some exceptional cases, a killing that is IHL compliant would violate the right to life, and then the question is when, yeah? And they deal with that whole question of aggression and killings as a result of aggression automatically being violations of the right to life.
But I think that this is exactly right where we started the discussion. I think that it's a key issue whether counter-terrorism is whether the approach to it offers one of those examples, right? Because those who are perceived by states as members of terrorist groups or whatever, or like organized groups, are being prosecuted for murder, for legitimate killing and warfare. And I think that it captures the difference between the way that we think about human rights in ordinary situations and IHL in a way that we gave up when we tried to merge the two regimes. Like if you look at just war theory, it's clear to the revisionists that there is a difference between IHL or like what's permissible in warfare and how we think about those things, or to what extent like the legitimacy of using force affects the permissibility of killing or the way that we deal with it. And I think that this is one area where states are not willing to compromise on these issues when it comes to equality of belligerents. I oppose this approach, but I think that in essence what it says that you should take into account some aspects of the characteristics of the different parties to the conflict and take it into account when you think about issues such as immunity from prosecution or how we think about it. And if we translate the act of prosecuting for murder as some kind of violation of human rights, it wouldn't be.
But it wouldn't be. So if a state tries a rebel simply for participating in rebellion, that's not a human rights issue.
No, but for killing inside of soldiers.
Why is that a human rights issue? It's murder.
Is it? No, definitely. But from like the group perspective. So for example, right, we go back to the issue of like.
If Ukraine tries a Ukrainian rebel for killing a Ukrainian soldier in combat, perfectly in compliance with IHL. That's not the violence of IHL. Ukraine has every right to try them for murder. It's not a human rights issue. There's no human rights of the person being tried that's been violated.
No, not of the man. I'm sorry. Right. So in our previous discussion, we talked about non-state actors. We discussed to what extent they have human rights obligations, right? So if you think about these non-state armed groups or there's group, their killing of legitimate targets, what does it violate or how we think about it in the intersection here? I think it captures the notion of the legitimacy or illegitimacy of the killing, and we can translate it to human rights in the conceptual sense, not in the international law understanding of.
Sorry, the point is the scenario you're asking about whether if a soldier of a rebel group kills somebody in combat, whether that's a violation of the right to life.
Kills exactly, including soldiers of the state.
So I suppose one can argue that, you know, that kind of killing of a soldier in combat is not a violation of the right to life. So what's the problem?
It would arise in the issue of investigation, right? If there's a duty to investigate the death.
By the non-state actor?
By the state. Should the state investigate the death of a soldier that was killed by a rebel?
Well, I mean, yes, in principle, but the question is it's a contextual duty. What does it actually require? So if the facts are completely clear, it has to be recorded, and then that's it. Like there's nothing else you need to do.
If the facts are not that clear, there's a duty to investigate any death in battlefield.
So this was the issue, remember, in the Jalud case. And the issue in that particular case was these people get killed at the checkpoint, then they're given to Iraqi authorities to do forensics and stuff. So it wasn't the Dutch soldiers who killed them. Then hand them over to some kind of Dutch military police who could, and Dutch forensics, whatever. It was the Iraqis who did the forensics, they did sloppily, whatever. The court was very happy, like it says in the judgment, we will give you a lot of leeway, a lot of flexibility. What happened on the merits of the case is that the Dutch spent half of their time arguing about extraterritoriality. They did not argue enough about the real practical difficulties of the issue, and they lost the case 9-8 or something like that. Yeah, on the procedural duty. But the court expressly said it's flexible. It's super flexible. So if you're fighting a war and people dying everywhere, you don't have to do the same thing as in a complete normal situation. It's basically the court's point.
But this is a checkpoint situation. In battle, do I need to investigate the death of each soldier, how it happened? It's not clear. It's always not clear who shot whom and so on.
That's usually what happens just for the sake of investigation of possible war crimes. They simply do. They investigate friendly fire. So there's a lot of reasons why they simply
investigate any friendly fire during battle. Why?
Yes.
20% of deaths would be friendly fire. You want to tell me that now I need to investigate all the deaths to see the 20% were friendly fire? There's a duty. It would be a violation of the right to life of the soldiers if I do not investigate the occurrences of friendly fire. That's crazy and unrealistic. That's completely unrealistic.
Depends on the threshold, the level of threshold.
In battlefield, in real battle, as opposed to checkpoint scenario.
Sorry, but when you say real battle, I don't mean while the guns are firing. Immediately you deploy the FBI and they start collecting all the information on it means you have to ask questions. Like if your soldiers get killed somewhere by your own artillery, you have to ask people what happened.
No, but wait, there's a battle. In battle, 20% of battle death would be friendly fire.
But you can't.
That's a statistic. I need to now to investigate the death during
the conflict.
Show me an army that does so.
No, it depends on
in the deployment, investigate
there's an investigation. Every incident is being investigated in the basic sense that.
And even in the battle,
like this is the practice. This is not.
We are now on D-Day. Okay, the soldiers are rushing to the beach. You want to tell me that a month later we need to investigate the death of the soldiers that were rushing to the beach who died by friendly fire?
But that's not the proper example, because that's like, that's a different situation. Now when soldiers go into battle, they have, for example, cameras.
Yeah.
Like I'm from the Czech soldiers who were deployed in Afghanistan. I have seen a lot of videos from the battle. They have small cameras on the top and they record for various purposes, not just the investigation, but for various purposes they record what's going on. Of course, it's certainly not possible to investigate, just as Marco said, to have a full investigation like we know in criminal proceedings, but there is a collection of information for various reasons, but mainly operational.
And there's a duty to investigate. There's mass deployment of soldiers, a huge battle, and now there you have a duty to investigate how each soldier died. As a duty, as a violation of the right to life, that's how they are.
But you're talking about two different things, right? About the duty, we can debate it, and you're talking about the practical ability to.
Question: what is expected?
I can tell you that at least when it comes to the things that I know, besides that, it's not only friendly fire. Like every incident in which soldiers are being killed, even by the enemy, is being investigated to some extent. Like it's important for the military to understand what
the reason.
The reason. Then you can talk about duties, whether it's important and so on. But like in the practical level, every
in relatively small scale operations, not when we now fight Egyptians in Sinai Peninsula. You want to tell me that they would investigate each death?
Yeah.
The point is that you never know who is going to die.
Like, at least in the unit level, and if something will be weird, it will go away.
That's actually a good thing.
The point is that you never know who is going to die, because your way of thinking assumes that it's like a clear situation when there is only friendly fire or only killing, the enemy, etc. But this is not how things are. So actually, there is in most combat situations, you have no idea who is going to die, whether it's your own soldiers or whether it's the enemy or whether maybe it's the civilians who come across. And then, depending on the victim, you might have different obligations when it comes to investigation.
Which proves my point that you cannot see it as an obligation in the course of large-scale battles to expect each and every death to be investigated.
The question is, what do you mean by investigated? So if by investigated you mean 10 police officers come, they conduct interviews, collect forensics, open a criminal record, that's not what is expected. Right there, exactly. It's expected that somebody checks what happened, and if there's something suspicious, to escalate it.
Exactly.
So imagine a situation where there's two soldiers who hate each other for some reason, and in the heat of battle, one of them shoots the other one, right? So and then says, "Oh, there was friendly fire." Like obviously, this is something the state should investigate.
In theory, in practice, I don't see anyone discovering it. It's happening on D-Day.
Well, maybe it's not going to be feasible. But the question is, you should do everything you can reasonably be expected to at the time. It's a very flexible obligation. Exactly. If you can do something, do something. If you can't do anything, you can't do anything.
I think that to expect, and again, the D-Day example is a good example because this is large-scale battlefields which haven't gone away from reality. They still exist and still happen. In such a situation, to say that sometime later, somebody needs to sit down and check what was the way in which each and every soldier died, unrealistic.
I think every family in Ukraine,
he died in the battlefield. Nothing else is said. To tell exactly what happened,
but you see exactly. To say somebody died in such and such a place, in such and such general circumstances.
You check do you need to check the bullet? The easiest way to check if it's friendly fire is to do an autopsy. Do you need to do an autopsy to check which bullet it was?
You don't need to do an autopsy of every person who dies in the battle.
But that's the way to discover friendly fire.
And sometimes you even cannot because of religious grounds, etc., etc. So, sorry if I may, because there was a question.
Quick question. I was wondering, what's the purpose of this investigation? Is the purpose to know what happened, or is the purpose to try the person that did the wrong thing?
If it's part of the right to life, so arguably it's to know how the person died, right?
No, to try the person.
To know if there was a violation of the right to life.
And in the following procedure, to try the person.
If necessary. If appropriate. But isn't this the same as the idea that you have to investigate into civilian deaths when there's I'm not sure the word suspicion is, that there's a suspicion that it's not just incidental injury? It's the same thing, yes.
Even in a completely peacetime situation. So when people die in Prague, not everybody's autopsied. Not everybody, the police don't come to the house of every person who dies in Prague to do every forensics. They only do it if it's suspicious.
By the way, there are
actually, that's interesting. Outside of the hospital, if there's always the police now.
Yes.
But never mind.
There's a slight
police arrive to the scene, but they can just say everything is fine.
Right. Yeah, no, which goes back to the obligation to ask the question.
Yeah.
Doesn't mean that you need to have the 10 policemen, whatever. But yes, but you have to ask the question.
But then, if you watch the series, you see they didn't suspect anything, but in fact, it was very sophisticated.
No, we are all experts on forensics. We know that. Yeah.
But if you look, for example, into the rules of engagement, even on we all know the rules of engagement, the higher you go in terms of the command, the bigger they are. But when it comes down to a simple soldier, it's just a card. But even that card usually contains, as a last point, the command to report every suspected violation of IHL. So even, the situation when you have a clearly a casualty in a combat, which is permissible by IHL, then I would agree with you, but you are saying no investigation needed in the sense, even though it's still happening very often, because it can have an impact on how operations are being conducted, what's the public opinion, and that's what was happening in Afghanistan, that in order to work with the public opinion, in order to provide accurate information, there were investigating things. Nevertheless, everything else, like friendly fire, etc., can be considered as a potential IHL violation, and the soldiers have the duty to report, which for me is a sign that apparently if they report, there has to be some sort of investigation. And as Marco said, the investigation does not have to be like a full-fledged criminal investigation in peace times, but according to what is possible. Because of course, if something is happening in Afghanistan, somewhere in the mountains, it's sometimes not possible for the respective soldier who is tasked with the investigation to come to the place for various reasons. But they still have the cameras, they still have the videos, based on which they can, for example, do at least partially the investigation.
But by the way, Martin, so there's the reverse scenario. So the scenario we're looking at now is this kind of soldier-on-soldier fire and so on. But a more typical scenario, like if you're Ukraine, you will have your civilians dying every day as a result of Russian fire. Yeah. So a Russian missile hits a building somewhere. Do you have, as Ukraine, the duty to investigate? Yes. Yeah. So it's a procedural duty to investigate how those people died. It doesn't mean you actually have to autopsy them. I mean, you're going to do some forensics. You need to identify who the people are. Yeah, you need to document what happened to them. You don't necessarily have to open a criminal case, especially because you don't know who the potential offenders in Russia are. But you have to do something to establish what happened to those people, right? And you're doing it in wartime when it comes to civilians killed by your enemy. I mean, to the extent you're able to. If there's a complete breakdown of law and order in a city, the city is destroyed. It's Mariupol, right? You cannot go safely into the city to investigate anything. Then you don't do it.
I'm not the certain point, feasibility and a duty. Like, of course I do it, but am I duty bound to do it? It's not the same. The fact that I'm investigating what happened, I do it sometimes even if I'm not duty bound to do it. I'm not certain there's a duty on government to investigate each and every missile leak if it can. I think that it's something that is done. I don't think it's a matter of a duty.
Doesn't go back to Minerva's presentation about the issue of burden in terms of human rights during the actual combat operation, to what extent taking into consideration these issues puts an unfeasible burden on the state in terms of protecting human rights. So it seems to me like that it's similar, that in principle we wanted the right to life of soldiers and so on being part of the way that we think that an army conduct its operations. But the question is whether we should investigate where the commander tells the soldier to stand, and whether it unnecessarily risks them in a way that violates their rights. And I think that we can ask similar questions about the duty to investigate. Right. We want, in principle, that a state that takes seriously the lives of their soldiers.
But it's a matter, is it a duty or it's something that is preferable? It's two different things. Has it come to the point where we see it as a legal duty of every state to investigate each missile hit if it can?
So under IHL, IHL says nothing about the duty of the state to investigate deaths among their own soldiers or among their own civilians. IHL doesn't really speak about that. It just talks about suppressing grave breach.
Human rights law, you assume that would create such a duty? The
standard approach under human rights law is I'm going to quote to you paragraph 27 of General Comment 36 of the Human Rights Committee. The obligation of state parties where they know or should have known of potentially unlawful deprivations of life to investigate and, where appropriate, prosecute the perpetrators of such incidents, including incidents involving allegations of excessive use of force with lethal consequences, blah, 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 blah. This is the standard approach of all human rights bodies.
But what is potentially unlawful? You mean when a missile hit,
yeah,
it's not necessarily that it was intentionally aimed at civilians or disproportionate.
Correct.
So it's not potentially unlawful.
It is potentially unlawful. It's not necessarily unlawful. It is potentially unlawful. The missile hit could be lawful, but it is potentially unlawful.
Every missile hit in battlefield once a civilian was killed is potentially unlawful.
Yes, Ukraine has a legal duty to document what happened to every civilian who dies in Ukraine.
Is it duty or as a matter of what we are
legal duty?
I think it's
I mean, so this is your opinion, but I'm telling you what human rights bodies have said.
No, so they are crazy. Well,
they're not crazy. They're not crazy.
But I think that maybe there is a middle ground here, right? Because the question is what does the duty actually mean?
But that's the thing.
And if the duty means we have a look, like a simple look, and say this makes sense, this doesn't make sense. If it makes sense, we have no obligation to continue investigating. If it doesn't make sense, then we continue. Then you can both live in peace and harmony forever, right?
This is the reality that destroyed entire CSI on conflict, right?
But it's a question to what extent actually the fact that we have an armed conflict and that we have an IHL not containing rules on this, there's no specific rules on investigation, just you said, except the grave breaches, is suppressing the international human rights law regime and obligations to investigate, which, as you provided,
there's no reason in principle it should.
So, sorry?
Why would it suppress? It would provide different substantive rules as to what is permissible or isn't permissible. But
suppressing in the sense of that we could argue, but it's a nonsense, that even in times of armed conflict, we need to investigate fully as if it would be in peacetime.
So that's not true.
We don't need to investigate fully.
So that's the point. So
again, if I may just again quote from Jalud, just because the question was addressed, right? So in Jalud, the court says the court is prepared to make reasonable allowances for the relatively difficult conditions under which the Netherlands military investigators have to work. In particular, it must be recognized they were engaged in a foreign country which yet to be rebuilt in the aftermath of hostilities, etc., 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 and there were clearly hostile armed elements in the environment in which they operate.
Is this refer to the investigation or to the legitimacy or to the legality of the?
No, to the investigation. And then in a joint concurring opinion, the judges say, it is clear, as the court has stated on several occasions, that where the deaths to be investigated occur in circumstances of armed conflict or in otherwise unstable region, obstacles may be placed in the way of investigators and concrete constraints may compel the use of less effective measures of investigation. The key question then is whether the investigation to the shooting was conducted in a sufficiently effective and diligent manner, blah, 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 blah. This is an obligation of results not of results, but of means.
And this is a case of clearly suspicious.
I'm sorry. If you allow, I have here.
Investigation is very useful for the right to truth that you talk about.
Yeah.
As if you want to establish the right to guarantee the right to truth to the relatives or the loved one of the people who are dead in the battlefield, you must do the investigation. It's a question of proof also according to the International Court of Human Rights. If you want to ask reparation for the people who are dead, you have proof when they for doing the next to the investigations.
I'm just thinking that I know that the Israeli, and this is practice, as to how long it must take. I don't remember which is about that Chekhanova. I don't know who they were. The Chekhanova committee. I don't know who they were and why they said that. But basically, an investigation of civilian death in armed conflict can take up to a year. Yeah, exactly. That was my reaction. So it's very flexible, and they consider it to be an obligation. Not an obligation to take a year, an obligation to investigate, which may take up to a year.
Civilian from the other side, but I'm giving them the call of civilian from our side. I don't see it.
No, the dispute of principle is still there, and haven't the
potential. I interpret differently potentially unlawful. I don't think that once a civilian was killed by a bomb, you immediately should assume it's potentially unlawful. This is where
But the situation that we're looking at in practice around us, it's where it's clearly unlawful. I mean, when there's a missile hitting Ramat Gan, nobody suggests that maybe it's incidental injury and therefore it's lawful. It's unlawful. We don't need to go any further.
But if who shoots it, if it's Iran, maybe it was aimed at the Mossad headquarters and then.
Yeah, exactly. So there's two, right? So it's essentially the case that we don't even think that it was actually the process of asking the question and giving the obvious answer. But yes, why wouldn't the question be there?
Because you're burdening the authorities during war with additional, more and more duties to the extent that it's unrealistic.
That's why they have an entire year. Yeah. And I'm beginning to think maybe they said it a year from the end of the conflict. No, that couldn't be.
So the question is this: if you ask the Ukrainian law enforcement people now, if you could just teleport them here and ask them about their experiences of documenting what happened to Ukrainian civilians in the conflict, and ask them if that was a burden on them, they would not tell you that. They would tell you that's their job. I mean, I've spoken to them, so I know. That's what they would tell you. They want to do it, partly because it's part of their strategy to show how bad Russia is, but they definitely want to do it.
And not only them, but also the other countries. Finally, for example, the Czech Republic has a system of reporting violations. So for Ukrainians coming here, and there was more than 300,000 of them, they can report. There's a special website through which they can provide evidence. So actually there is criminal investigations even here in the Czech Republic. So, and there were
from the initial stages of the invasion, the Prosecutor General of Ukraine did it.
So we move from taking someone's phone,
taking someone's life. That's
investigating the death of legitimate targets, whether yes or no. But that's quite a journey.
Yeah, it is. But still, we are sort of moving within that area of tension between IHL and international human rights law. And I was suggesting detention and targeting, etc. But we are still moving. It's the same discussion. It's just where are the lines, how they interact, to what extent we can actually use, and we should use human rights rules where there is no specific IHL rules. And that's applicable to all the areas which we were mentioning. So we moved quite a lot in the specific context, but we actually are still circling around this tension. So,
and then, like 2 points that relate. One goes back to the phone, and the other further. We didn't cover like a third scenario with the phones. where it's not on the person but at the house, so it's not hacking and it's not physically with the person, so the state just takes the phone. Where do you put it in the jurisprudence of the court?
It doesn't. So if they take the data back home,
no, they don't take the data.
But
They just have the phone and they analyze everything.
There's nothing in the jurisprudence of the European Court that's exactly on that topic. I mean, you could so it's a question from normative principle. What you think the right result is? I think the result would be the same. But there's nothing in the actual case law on that.
So within jumping a little bit to the next roundtable on technology, when you say take the data home, where is home if I just put it on the cloud, which is
very good point
everywhere?
Very good point.
Home is where the heart is.
Where you're happy.
Where the cloud is.
Yeah. So home is everywhere. Yeah.
Very good point. So the European Court doesn't address the cloud problem.
And also one of the issues which we already actually raised, but we did not stop at it, whether actually data is an object in the sense of IHL, and to what extent actually, or how we would interpret this, because under IHL we do not really have anything which would help us to say. Usually in IHL an object is something which is physical rather than metaphysical, etc. So in that sense, for example, I would be just interested in your opinion, whether it's for you quite natural, just as you simply assume that it is an object, because only then we can actually apply the basic principles of IHL, then say that if we have military necessity and proportionality, we can just continue as usually. But if not, then we actually have a problem, because then it's not regulated by IHL. So then how we actually define this specific issue?
This is actually an unsettled issue within the Tallinn manual. One of the, and among others, unsettled issues within the Tallinn manual, and the Tallinn, the Tallinn manual experts, they say that it's not a protected object because it's not a tangible one, but but there is a disagreement between states regarding this issue. Like I can tell you the exact state because I'm a researcher of that, but I want just to tell you that some states said it is a legitimate object data, and some said it's not. So it's unsettled, and it's here unsettled with regards to IHL rules, and it's not something that, for what I know, it's not something that we know yet if it's targeted, if it's considered to a legitimate target or not. So it is a huge question actually under the the issue of cyber warfare. But the Tallinn manual, which is the most relevant instrument today, that interprets the IHL and apply it to cyber operations, say it does not, because it's not tangible, and target should be like you said, physical and not something that you can say. But personally, I don't agree with that, because today, as I know, and also from the researchers, also from the real life, I know that it's targeted and it can hurt, and it can hurt human rights. It can impact human rights definitely when you steal data or you can alter data, and so personally, I think it should be, and maybe it will, in the future. But for now, it's still uncertain. This is one of my questions in my research, actually.
But it doesn't like the phone in your example.
No, I don't mean the phone. The phone, it's a physical.
But
I mean
data. But the data on the phone. I mean, today the phone is tangible, obviously. But
it doesn't have to be on the phone. It can be on the cloud, right?
The phone connects to the cloud, and if you have the phone, you theoretically have access to the data. So it's like, I'm not familiar enough with this object issue, but
obviously the phone is an object.
Yeah, but I'm not talking about the feasible phone and taking the phone. I'm talking about
the data.
The data.
Yeah, but what I actually wanted to say, like in your example,
I understand.
There were civilians. And so that probably wasn't a matter of cyber warfare. It was just a matter of
cyber warfare. I just took it to the direction of cyber warfare and telling that with cyber warfare, it is a matter of contestation with all the data thing. If it's regarded.
Not here. Destroying or seizing the enemy's property. If the destruction or seizure is not imperatively demanded by the necessities of the conflict. And so the question then could be, imagine Russian forces go into occupied Ukraine, they take intellectual property of Ukrainian companies in occupied territories, stuff like that. Mm-hmm. Can data, intellectual property, those kinds of things qualify as property of an adversary in this kind of context? And then how do you apply the necessity criterion to that kind of stuff? So in the physical world, the example is you're bulldozing areas of Gaza because you want to do X. Yeah. Now in the cyber context, the question is whether taking those things is property and whether seizing it or destroying it is necessary. So the question is, how do you justify it? Yeah.
So if I steal the plans to create a new missile, it would be okay. But if I steal company information in order to invest in the stock exchange,
probably not.
But stealing is not
how
seizing.
What would be the outcome with regard to money?
Depends on what you do with it. Huh?
Depends what I do it was what they're aiming to do it. I mean, if it's money that aims to support weapons, etc.
It is justified by reasons of necessity of the conflict.
Yeah, that's it. There's a series of rulings of the Israeli Supreme Court on that.
Plunder, whatever. Yeah.
No, the issue was the private banks in the West Bank, which they are called money exchangers, but they are actually private banks. And the Hamas uses them, but other people use them as well. And the question, how do you...
the money of
how do you know decide which money you take or not? And there's a series of rulings of the Israeli Supreme Court on that.
If you copy it and take it, is it seizing?
Interesting. I don't know.
If you copy, alter it, and seize the original,
I don't know. Like it hasn't. It's probably never going to be litigated because the question is, will it satisfy gravity criteria? But you see what I mean? The crime is written as it is written.
No, but it can be litigated under like IHL. It's an IHL violation, not a war crime, right? In the European Court of Human Rights, if they decide that they
but it is
discuss conduct of hostility.
But by the way, that is super easy in principle because Article 1 of Protocol 1 of the Convention protects the right to property. Right? So you can totally litigate this stuff in the European Court of Human Rights. And then the question is, how does the right to property in the European Convention relate to IHL rules of the taking or destroying property? I mean, it has never been done, but I mean, it's easy to do in theory, right?
Isn't there any case law from the Nuremberg trials?
There is on plunder, that type of stuff. There is all that.
The definition there is wider of pillage. In Nuremberg, the definition of pillage is wider than the current definition.
We have 15 minutes, but if there are no further, let's say, comments on this, I would still have one, let's say, interesting issue, and that is the security detention. The point is that security or preventive detention is one of the lawful measures states can take, apparently, under IHL, even though there is under in situations of international armed conflicts, no specific rule, and when it comes to non-international armed conflicts, we are missing any explicit rule permitting or authorizing security detentions. Where it gets particularly problematic is that according to IHL and in non-international armed conflicts, we have rights and duties applicable to non-state armed groups, right? Whereas when it comes to the obligations or any, let's say, kind of regulation when it comes to detention or the right to detain, to do security detention, but also any kind of criteria or guarantees against arbitrariness of the detention, there are non-existent in non-international armed conflicts. So what I would be interested in, if there are any thoughts on how, in these cases, then international human rights law comes into play in such situations when we have a clear lack of any regulation under IHL, but apparently there is a need to have at least some basic guarantees in such situations, such as security detention, especially in the context of non-international armed conflict and non-state armed groups.
Can I have a twist?
Sure, go ahead. It was just a suggestion.
Now I feel like shit. Because it goes back to the discussion, and I think that we frame like two versions of using human rights in the context of IHL. One was an interpretive role of vague or unclear IHL obligations, and the other is where we have gaps. And it really affects, it depends on your position, but the duties and obligations of non-state actors. Because if we use the interpretive approach, then we can easily say non-state actors in these contexts have these obligations. This is their IHL obligations. But what do you do when you say there's a gap in IHL? The states are obligated to follow human rights, but then what you do with non-state armed groups, and it's especially true when these armed groups do not control territory, and so many things that we discuss here are not related to control of territory in the sense of like the checkpoints, the data, like what is the form. And I think that we tend to push very hard towards human rights as a solution, and we don't necessarily follow the right complete these pushes by insisting on adopting a broader theories of how non-state actors are obligated by human rights as well. And it comes right, so the detention issue is clear, right? So exactly. We can think about like human rights law as a way that states are still bound by the rules, but what do we do when it comes to non-state actors?
That's the point.
In these cases, it's easier because usually if they detain, they control some territory, but what about obligations that do that?
So if I could just add, the practice of this, of missions of inquiries and rapporteurs and the variety of those soft law things, is to the extent that they hold armed groups to have human rights obligations, it always has to do with those being the very fundamental rights or peremptory norms or something. They use terminology which ends up being the right to life and physical security and freedom from torture, something. They don't go to freedom of expression and the right to health. But it doesn't solve the detention issue.
They talk about territorial control.
But that's something which we have guaranteed already by Article 3, right?
There's the sections there, but even then they speak of, and we talked about that before you got here, that it's always about actually the de facto control, not the organized armed groups, but it's the combination of the two. But they never go beyond those very fundamental rights, and all rights are created equal, but some rights are.
So our discussion like 2 days ago, just to conclude, it was why do we insist so much on territorial control, where in some ways it's a parallel discussion to the extraterritorial application of human rights. Why can't we just apply the same tests to the question of non-state armed groups and human rights obligations? Because the logic seems to be the same, right? So we can.
The answer,
like the negative.
The answer is political, which is that all of these bodies which are pushing the law, because the law is state-centric. So the treaties as written are state-centric. So all of these bodies, commissions of inquiry, special rapporteurs, which have pushed the application of human rights standards to non-state actors, have tried to find a way to make it more palatable to states.
Well, states will.
So that's why they said, well, not really, because there are many other contexts in which states are resistant to say, that non-state actors have human rights obligations. The main one is companies. So you have negotiations now on this business and human rights treaty. Still to this day, states do not say that companies have direct human rights obligations. So because they don't want to say it. So then the whole territorial control business is really a way of finding something.
Well, but we know of cases where these bodies emphasized non-state armed groups as something unique. So if you think about the Tajik and the overall control test, they emphasize that they talk about situations of organized armed groups, and they will not necessarily apply the overall control test to any. These are different actors.
I don't disagree with you. I just explained why.
No, I'm saying that you can solve the political issue if you focus exclusively on non-state armed groups as a unique case of this type of thing.
The good point is that actually we do have a very basis. The very basic
IHL obligations. So how come they don't get like?
But they well, actually, if you look in Article 3, it's not only typical IHL obligations, but the prohibition of torture,
human rights stuff.
It's your human right itself. So actually, there is already like these basic human rights integrated in the IHL as a very basic guarantees. But the question is, what comes beyond, let's say, this point of the fundamental
and they
guarantee.
They mentioned the possibility of trials by non-state groups, right?
Yeah.
So the deprivations of life shall not be done without a trial, with all the guarantees recognized as indispensable. So Article 3 does recognize that.
Yeah, the question is what do we do with what is not explicit?
Sure.
So what is explicit is not entirely coherent in terms of maybe it's not the most fundamental thing. Mm-hmm. But it's strict that leads to execution, if I remember correctly.
Mm-hmm.
So it's
deprivations of life.
Exactly. So.
Any other comments or questions?
We've solved.
We've reached this.
Okay, give us a conflict. We'll resolve it. We've gotten so much, and then.
World peace in 7 minutes.
So the hardest questions on detention issues are what kind of control and what kind of process. Huh? So do you need to have judicial control of deprivation of liberty, or is less than that fine? And as you all know, in IX, we have rules that say less than that is fine. Administrative boards in Geneva 4, that's fine. Now, if that kind of question gets litigated before a human rights body, many of them will be tempted to say, no, we don't care what the Geneva Conventions say. It needs to be a court, at least after a certain time. Like if you're keeping people, imprisoned for years, there has to be judicial control of deprivation of liberty.
Since we have the last 5 minutes, allow me to misuse this form for actually getting the answer to my very first question, because actually, if you notice, I didn't tell you what I thought the legal service. So I would be actually very keen to hear whether you have any opinions. What would you answer the legal service? So is the refusal to let's say, grant access to the phone itself a security threat, which under IHL is enough to warrant the security detention, or taking into play human rights, actually, and the whole context, you would say, no, there must be much more than just a refusal to provide access to the phone.
It doesn't seem to me like a matter of degree, but rather the refusal. If the refusal is, assume the refusal is legally legitimate, and then it's only a question of a security threat, which is not a matter of law, it's just a matter of, I don't know, intuitively something sounds to me wrong in saying the fact that you won't let us do what we want makes you a security threat.
We call that counter-terrorism.
Yeah, I'm not keen on terrorism and everything that comes with it, clearly.
A lot depends on the context in which this is.
I know. Well, just to tell you, my answer was it's not enough. Exactly because of how I consider the relationship between IHL and international human rights law. And we have simply the legal basis in international law for saying that the fact that we have an international armed conflict or armed conflict and IHL applies, that does not mean that the human rights do not apply. And if we look in the ICCPR and other relevant human rights treaties and norms, I don't see a reason why they should not apply also in this kind of context, at least to the extent of saying that this is simply not enough to warrant the access or to enforce the access to the phone by detaining the person.
Not enough in what sense? What there needs to be more risk, more resistance, more what?
Other circumstances that would create or that would warrant the view that the person is a security threat, because that was basically the question that they were saying, the person is not granting us access to the phone, that's why the person is a security threat.
That makes everything, any resistance to police action a legitimate basis. If it weren't like you said, then there would be no bars to security services action. Yeah, no, I agree.
By the way, there's a nice. I'm just open something, but because I can't remember all the details, but it's something you may want to look at. In American Fourth Amendment jurisprudence, the Fourth Amendment, you'll remember, prohibits unreasonable searches and seizures. They have a particular exception, which is called the border exception. So when you're at the border, the U.S. border, you don't have this right. Mm-hmm. Yeah. So every one of us who travels to America, remember, they can actually ask you at the border to unlock your phone. Yeah. And then, so they have legally, that's what they do. Yeah. So they do it to citizens. They don't just do it to non-citizens. Now, for non-citizens, what they can easily do to us if we don't unlock the phone is they can just deport us back, right? But for citizens, the question is, what do they do to them? And so I think you could maybe look a bit into that. I mean, there is litigation on this, you know. And now, if you apply for American visas or if you do ESTAs, they ask you to provide all your social media accounts. Really? Yeah. If you have handles, if you have Instagram, whatever, you're supposed to put it all in.
But not the same.
But there's a difference between we want to see who you are. And we want access to your private profile.
But they can use that at the border to say, you know, we think you're suspicious for some reason.
No, but it goes with immigration. They have valid discretion in immigration. They're making their lives easier.
That's for the foreign one.
Yeah.
But they can do it to citizens too.
Right.
So you're an American citizen, they can unlock your phone at the border.
Yeah, I'm related to social media. No, all I'm saying is I'm not impressed by the social media thing. What's instead of asking us to tell them about ourselves, they just tell us what you've told the rest of the world about yourself.
And now we fluently came to other questions, which I think are perfectly fine for the coffee break. So let me thank you all for this roundtable, and
thank you.